Sanbonani, Mweni, Dumelang, good afternoon. Wamkelekile. Welcome to the webinar hosted by the Navi Pillay Research Group of the School of Law of the University of KwaZulu-Natal. My name is Valine Holness. Today, on behalf of the Dean of the School of Law, Professor Manigay Reddy, I wish to welcome you. Unfortunately, she's unable to do so herself due to other pressing concerns. The Navi Pillay Research Group is a collaborative project that is comprised of a number of researchers at the School of Law and outside of our school. And we seek to honor the formidable legacy of Dr. Navi Pillay, a UKZN alumni. As you may know, her path-forming work in securing redress for victims from the apartheid era and her continuing tireless work post-apartheid era has set her as a beacon for upholding human rights. She has confronted crimes against humanity, mass atrocity, and genocide through the tribunals of the ICC for Rwanda and the International Criminal Court. Her contributions, including working for the United Nations High Commissioner for Human Rights, has set up a normative framework at the international level for justice, including on gender-based crimes. So the Navi Pillay Research Group is an interdisciplinary collaborative project that supports research, education, policy, and advocacy interventions to respond to contemporary social issues, such as the ones we've been facing in South Africa in the last few months. We seek to address emergent issues of race, class, gender, and disability in post-apartheid South Africa. So over the last few months, the Navi Pillay Research Group members have debated on how to start working towards building respect for the rule of law and the legitimacy of the state. To that end, we wish to address divisions, including in the police, prosecutorial services, and the criminal justice system, including the intelligence areas as well. We seek to obtain accountability and justice for incidents of incitement to violence, vigilantism, and racism. We are deeply aware of the context in which we find ourselves, the socioeconomic one, which is deeply unequal, as well as the pressured political context of our times. We hope to stimulate debate on these issues, and to that end, we will also host a second seminar on the 3rd of November titled Criminal Justice and Social Cohesion, and we wish to invite you to that as well. It is with much and immense pleasure that I welcome you today to continue this debate on the theme for our two seminars, Things Fall Apart, the Rule of Law in Unprecedented Times. Today, we will welcome Advocate Tembeka Mbukaitobi, and his topic is in the constitutional implications of the July unrest. I seek to invite you to please feel at home with us today as we engage on these critical issues, and I will hand over to my colleague, Professor Chivasi, who will be our moderator for today's proceedings.
Thank you so much, Vilian, for the welcome that you've given us. As you've already heard, ladies and gentlemen, I am Professor Chivasi, and I will be moderating the event for this afternoon. And before introducing our guest speaker, I would like to talk about a few housekeeping matters first. Number one, our guest is going to be speaking for less than an hour, at least that's what he has told me, for less than an hour. And then thereafter, there will be a Q&A session where our guest speaker is going to take some questions. And with regards to that, ladies and gentlemen, I wish to bring to your attention that questions would only be taken via the Q&A function on Zoom. So please, ladies and gentlemen, if you wish to pose any question to our guest speaker, make use of the Q&A function on Zoom. Don't use the normal chat function, but use the Q&A function on Zoom. Finally, ladies and gentlemen, before I introduce our guest speaker. I must also point out that our speaker would only be able to take the amount of questions because he has another engagement shortly after this event. So as a result, he would only be available for a limited time after the event. So we'll only take a limited number of questions. So, but yeah, we will take as much as we can. So if for some reason your question is not taken or is not answered, please, ladies and gentlemen, do understand that our speaker has got another engagement shortly after this event. So those are a few housekeeping matters I wanted to bring to your attention, ladies and gentlemen, before we begin with the speech of our guest speaker. So let me take this opportunity, ladies and gentlemen, then to introduce our guest speaker, Advocate Tembeka Nkaitobi. Esteemed guests, colleagues, students, it gives me enormous pleasure for me to introduce our guest speaker this afternoon, who does not really require introduction, I must say that it doesn't require any introduction, but as a matter of formality, there are some quick facts that I wish to bring to your attention. Many of you will know about the things that I'm going to say about him, but nevertheless, I feel I need to do this. Advocate Tembeka Nkaitobi is a legendary lawyer, we all know that, and is also an adjunct professor at Nelson Mandela University. I need to point that out. And Advocate Tembeka Nkaitobi holds a BProc LLB degrees from the University of Transkei, and now Walter Sisulu University. And he also holds an LLM from Rose University and another LLM from the London School of Economics. Tembeka Nkaitobi served as a law clerk for the Chief Justice Charles Carlson, as he then was. And I must say that I was privileged to have an opportunity to serve at the Constitutional Court with him at the time. I was serving for Justice Kate Oregon. So we have known each other for a long time. So I'm very pleased that we've got this opportunity this afternoon to hear from him. Ladies and gentlemen, I must also point out that Advocate Tembeka Nkaitobi later served as an attorney for many years at ENS, rising to the position of partner before joining the bar to practice as an advocate. And he was also the head of the Constitutional Litigation Unit at the Legal Resources Center. Some of you who operate in the field of constitutional law will know about that. Ladies and gentlemen, something which you know quite well is that Advocate Tembeka Nkaitobi has appeared before the Constitutional Court and many other courts in this country on a number of occasions, often appearing on high-profile cases, including cases relating to the State Capture Commission more recently. So many of you will know and would have seen him appearing before these cases, because some of the cases that he tends to do attract a lot of media attention. So hence, I said it doesn't require any introduction. Many of you will know about him. Many of you would have seen him on TV. And ladies and gentlemen, with those few facts, it is really such a pleasure for me to introduce to you our guest speaker this afternoon, and I invite him to address you, ladies and gentlemen. Thank you. Advocate Tembeka Nkaitobi, the platform is all yours.
Thank you, Professor Chivase. I must thank you for such could describe it as a generous introduction. A lot of things you've said, I'm not sure sometimes if I deserve them. But nevertheless, I want to appreciate your invitation and the generosity you've extended. I must also thank Velin because I actually used to work with her at the Legal Resources Center. I wasn't aware that she is now joined the academic community, it's always pleasing to see people that were in practice teaching law to students, because that gap sometimes can be difficult to navigate, the gap between practice and law. And I want to thank your faculty, I think it's called the school, for extending the invitation. Although the dean is not present, I've been made aware that she would have preferred to be here, but has had other engagements. And also I think it's the Navi Pillay research group that conceived of this idea and also decided that I should be one of the speakers. So it is a great honor and an immense privilege that I am here to speak. What I want to speak about is a broad topic under the umbrella of things fall apart. How should the judges, or how should the rule of law sustain itself when it is under political pressure? And though it is a tremendously important topic and an intimidating one to tackle, I want to start by telling 4 stories. At the formation of the apartheid state, the rule of law was already placed in crisis. The National Party had won the 1948 whites-only election under the slogan of apartheid. One of its main targets was to remove colours from the voters' roll, to complete the idea of making South Africa white. It introduced legislation to achieve this, to remove colours from the voters' roll and to place them on a separate voters' roll. But unfortunately, the applicable founding statute of South Africa, the South Africa Act of 1910, provided that for such legislation to be passed, a 2/3 majority of members of parliament was required. But the National Party disregarded the requirement and passed the legislation by a simple majority. When the legislation came up for consideration at the appellate division, it was invalidated, the court holding that the measure was invalid, null and void, and of no legal force or effect. That decision of the appellate division sent the government into a political tailspin. The government announced publicly that it would not accept the decision of the court, and it would find alternative means to express what it called the will of the people. When they attempt to undermine the decision by making the decisions of the appellate division subject to a High Court of Parliament failed, the National Party responded by packing the appellate division, creating a special quorum of 11 instead of the usual 5 for appeals regarding the validity of legislation. With this new measure, the National Party got its way. The new legislation removed the colours from the voters' roll. It was passed. A majority of 10-1 confirmed its validity when the matter came before the appellate division again. This deliberate undermining of the role of the judges was not the first time. Some 50 years earlier, there had been a bruising battle between the politicians and the judges. The scene of this battle was Paul Kruger's independent Boer Republic of the Transvaal. The case was Brown versus Leeds. The issue to be decided was whether the Volksraad, the governing body of the Transvaal under the presidency of Paul Kruger, could pass resolutions that override the Grondwet, the constitution of the Transvaal. Paul Kruger believed that the Volksraad, as the representative of the will of the people, could not be overturned by judges. When the issue came before the courts, the power to test the validity of legislation, which conflicts with the constitution, came sharply into focus. The year was 1897. The place was Pretoria. The court, under the able leadership of John Kotze, a man from the Cape who had been specially appointed by President Burgess to be the head and chief justice of the Transvaal Supreme Court, had the matter. He decided that the Grondwet could not be undermined by the mere passing of the resolutions of the Volksraad. He found that a constitution is in fact and must be regarded by the judges as a fundamental law. A popular government that exists under a constitution, such as the Grondwet, has a fundamental law that prescribes the manner in which the legislature is to declare its will for it and have the force of law. The duty of the court, Chief Justice Kotze had, is to test whether the legislature's expression of will is a law or not, in form, but also in substance. The right of the judicial organ of state to test the validity of the laws passed by another organ of state should not necessarily be formulated in a constitution. He thereafter invalidated the resolution of the Volksrat. There was immediate crisis. Paul Kruger would not accept the decision. He piloted a law to prevent what he perceived as judicial overreach. Law 1 of 1897 was published in the Government Gazette of 3 March 1897. The law stated that the judges had an obligation to swear an oath that they would not arrogate to themselves the right to test the validity of the resolutions of the Raad. If the judges exercised this testing right, they could be charged with misconduct. They could be tried in a special court, and they could be punished criminally. But that law itself would come before the Supreme Court, again under Chief Justice Kotze. But the Chief Justice of the Cape, Henry de Villiers, attempted to mediate the impending political crisis. In that mediation, Paul Kruger agreed to withdraw the law, and the judges agreed not to exercise the testing power. The following year, Kruger won the election, but he had not acted on the promise to withdraw the law. Kotze insisted on the withdrawal of the law. Kruger refused. Kruger wrote to Kotze on the 16th of February, 1898. He told him in clear and uncertain terms that, to my regret, you are discharged from office as Chief Justice. Many judges had promised to resign alongside Kotze, but none of them did. Judge Gregorowski, who had declared that no one should occupy the position until Law 1 of 1897 was repealed, took the position of Chief Justice. Aiselen, another member of the bar, had declined the offer. Judge Ameshoff resigned, not in sympathy with Kotze, but because he had been overlooked for the position of Chief Justice. Kotze had lost, the judges had lost, but the court would continue, but its standing significantly diminished. It no longer had the power to test the laws for the validity by reference to the Constitution, the Grondwet. Its position was now clearly subservient to the Raad. Another example closer in time is the disaster of the land reform program in Zimbabwe, which broke that country's constitution. In 2000, the judges increasingly ruled that the government's land reform program of Zimbabwe was unlawful. The ZANU-PF organized so-called war veterans to invade and occupy white-owned commercial farms. A ruling was made that those occupations were unlawful. They broke the law of Zimbabwe. They broke the fundamental law, the Constitution. A judge, Judge Paddington Garwe, decided on the 17th of March 2000 that all squatters in the farms should vacate within 24 hours. He directed the Commissioner of Police to instruct his officers to enforce the order, but the order was disregarded. The police simply did not enforce it. On the 10th of November 2000, the matter came before the Supreme Court. It confirmed the validity of the High Court order, instructing the police to act on the conduct of ZANU-PF and its so-called war veterans. There was an immediate standoff. A political crisis was looming. The government used various strategies to bring the judiciary under its direction and control. These included a combination of attacks and inducements, financial and otherwise, to attract the judiciary. Matters came to a head on the 24th of November 2000, when the war veterans forcibly entered the Supreme Court, where judges were about to hear another case by the Commercial Farmers Union. They shouted ZANU-PF political slogans, and they called for the judges to be killed. In December 2000, President Robert Mugabe described the judges as guardians of the white racist commercial farmers. His Minister of Information, Jonathan Moyo, would accuse the Supreme Court, particularly Chief Justice Anthony Gabe, of being biased in favor of white landowners. President Mugabe would also accuse Gabe of racism. Patrick Chinamasa, the Minister of Justice, told Justice Gabe that the government no longer had confidence in him. He instructed him to step down. Chief Justice Gabe resigned in March 2001. The rest of the members of the Supreme Court were asked to resign. This cascaded across the judiciary. Justice Michael Gillespie went to exile. Justice Ishmael Chatikobo also did. Justice Sandra Mungwira went to exile after she had acquitted 3 MDC activists accused of murder. Justice Ahmed Ibrahim, Justice Deviti, Justice Nick McNally were all forced into exile after they received threats of violence when they accused the government of undermining the judiciary. In 2004, Justice Michael Majuru fled into exile and faxed his resignation letter after he was publicly criticized and threatened with investigation by the government when he ruled in favor of an independent daily newspaper that the government had banned. What do these 3 examples show us? When there has been a direct confrontation and conflict, judges have had to back down. Politics has always won. How has our judiciary fared in the post-democratic era? This judiciary, South African judiciary, has been hailed as a model for the world. Indeed, in its
ladies and gentlemen, we do appear to have encountered a technical problem there. Advocate Tembeka Ncukaitobi, can you hear us?
Yes.
Okay,
yes.
Please carry on. We lost you there. Your picture froze for a moment.
Thank you, no problem.
Got you back now.
Thank you. Our judiciary has produced acclaimed judgments on topics such as social and economic rights, executive and legislative accountability, civil and political rights. It has withstood vicious attacks from politicians and disgruntled litigants. It remains a beacon of hope based on the rule of law and constitutionalism. In fact, it was Nelson Mandela himself who bequeathed this function, the function of guarantor of the constitutional project, to the judiciary. Remember his speech on the 14th of February 1995, when he declared that the future of our democracy hinges on the Constitutional Court. So far, and luckily, our judiciary has fulfilled Mandela's wish, but it has not been because the politicians have not attempted to undermine this. Take, for instance, the statement made in 2005 by the ANC, which accused at that stage the judiciary of refusing to follow the collective mindset of the will of the people, of intentionally undermining transformation. Those sentiments, sometimes construed as popular, but in reality populist, continue to reverberate across the judiciary. Recently, in July 2021, our judges and the rule of law were put to the test. The case was State Capture Commission versus Zuma. The Constitutional Court had given an order which was intentionally disobeyed. The court explained in its own judgment, instructing the imprisonment of Mr. Zuma, the impact of the decision to intentionally disobey a court order. Interestingly, it did not do so in narrow judicial terms, but by reference to the entire democratic project. It said, if the state an organ of state or state officials do not abide by court orders, the democratic edifice will crumble stone by stone until it collapses and chaos ensues. A complete denial of judicial mechanisms would render meaningless the whole process of taking disputes to court for adjudication, and that is a recipe for chaos and disorder. So when the court decided on incarceration, it was in fact a fulfilling Mandela's wish for the court to be the guardian, not just of the constitution, but of the democratic enterprise. Although there was intimidation directed at the judges, threats of violence, threats to the individual judges, the rule of law, at least temporarily, held sway. The order of the Constitutional Court was carried out. State institutions did their function. But your topic for today cannot be properly examined by an analysis of 4 instances of political conflict involving judges. They may not in themselves be reflective of crisis, but perhaps reflective of symptoms of crisis. What we need is a structured analysis to understand the structural constraints facing the rule of law and the project of adjudication. We should examine how judges ought to respond to these for the rule of law to thrive. I suspect that I have got ahead of myself. I should first be asking, what is the rule of law? How might it unleash the emancipatory forces of politics? And what are its constraints? The elementary dimensions to the conception of the rule of law emanate from A.V. Dicey, who defined its 3 meanings in England. 1, no one can be made to suffer punishment or pay damages for any conduct not forbidden by law. 2, everyone's legal rights and liabilities are determined by the ordinary courts in the public square. 3, everyone's individual rights are derived from the ordinary law of the land, with the result that the English Constitution is the product of the ordinary functioning of the courts. Dicey, of course, was writing in 1885. Since then, there has been a richer, a much more substantive conception of the rule of law. Indicative of this substantive conception of the rule of law is a recent 2020 rule of law report of the European Commission, in which it says that the rule of law means all public power are constrained by law. They are to be exercised in accordance with the values of democracy and fundamental rights, and under the control of independent and impartial courts. In this sense, at least, the European Commission makes it clear that political power is subservient to judicial power. It continues, the rule of law includes principles such as legality, transparency, accountability, democracy, pluralism, legal certainty, prohibition of arbitrary exercise of power, effective judicial protection, and independent and impartial courts. Of course, one might question whether or not a rule of law conception that does not include equality is in fact sufficient. Our Constitution, I want to suggest, embraces an even thicker conception of the rule of law that includes the imposition of constraint to governmental power, but the enablement of the transformative vision of the Constitution, the setting and the settling of rules in a non-arbitrary manner. But on a structural level, the rule of law is constrained. Crises or moments of crisis are usually reflections of these constraints. Let me explore some of these constraints in the remaining period that I have. The first one is legal culture. By legal culture, I draw, of course, from Karl Clare, where he criticized the inherent conservatism, which is in the habits and minds and intellectual reflexes of the judiciary in a collective sense. Although Karl Clare wanted to expose the fallacy of a disconnect between law and politics. He did not, in fact, succeed in doing so, because his thesis was confined only to legal adjudication. Yet my own thesis links legal adjudication with internal and external political pressures. So the perceptions of judges of the world are shaped and influenced by the world itself, that is, their world. In turn, these perceptions do influence judicial decision-making. Adjudication, therefore, cannot entirely be separated from politics with a small p. It was, in fact, Judge Pius Langa who pointed this out, that the apartheid legal culture was to deny the political influences on adjudication. And he then criticized the denial of the political influence in adjudication. Although there is undoubtedly political influence in adjudication, one must be careful not to draw the conclusion that judgments are mere pale reflections of the political desires of the judges. Instead, they are an engagement internally and externally with politics. When the judges pronounce their judgments, the judgments themselves are not political statements, but they undoubtedly impact on political choices. Returning to the topic of legal formalism, Justice Johan Froneman, a former member of the Constitutional Court, remarked that South Africa's legal culture still privileges formal rather than substantive reasoning. He pointed out that a belief to the contrary is delusional. And he also suggested that there is danger inherent in formalism. The substance of the law is overlooked in favor of the form in which the law is expressed. And that could stunt inquiries into interpretations and meanings consonant with the Constitution, and therefore obstruct the urgent constitutional undertaking of eliminating injustice. Yet at the same time, Justice Langa pointed to the dangers of an unbridled, open-ended judicial determinations that sidestep the textual foundations of law. Law, he said, does not mean whatever we wish it to mean. And in this instance, we are constrained by the principle of separation of powers. My point, however, is not to choose whether Judge Langa or Judge Froneman was correct, but it is to point out that legal culture is a constraint to the rule of law. The formalistic notion of the legal culture constrains its emancipatory potential. I want to move to a second constraint to the rule of law that might situate the July 2021 events in a larger historical and structured context. And it is the shifting patterns of inequality since the demise of apartheid. Although the core of apartheid was political, primarily implemented by carving out certain parts of the country as Bantustans and self-governing territories and denying franchise to Blacks living in white South Africa. The fact is that apartheid also had economic underpinnings. Its consequences was to produce untold social and economic inequality. And the truth is, the change in the political landscape did not change the underlying social and economic circumstances of Blacks. It simply opened up the possibility for change. Scholars recently point out that not only did it open the possibility for change, but it also opened the possibility for the continuation of the previous order. So as we speak now, the move towards egalitarianism, informed by the Constitution, has not materialized. Instead, the economic upper echelons have deracialized at a remarkable pace, effectively creating a superclass, while poverty at the bottom half of the population has become entrenched, creating an African underclass. Take what Sampete Blanche has said who says that one of the most remarkable developments in the past 20 years, at the time he was writing, that was 10 years ago, was the enrichment of the top 20% of African households and the simultaneous impoverishment of the bottom 40%. While the income of the top 20% of African households, that's about 6 million people, has increased by more than 60%, the bottom 40%, and that's about 18 million people, has declined by almost 60%. In certain quarters, there is some cynicism about the development of the so-called Black elite, but it may also be seen as a healthy phenomenon, without which the new South Africa would simply not be possible. But this underscores a broader claim that the development of the Black elite has coincided with the development of a Black underclass. So unless the rule of law focuses on equality as part and parcel of the substantive notions, we can expect the repetition of the July 2021 instances. For the rule of law to prosper, the central message emerging from the changing narrative of the nature and causes of inequality is not to be caught in a time warp that is blind to the gradual but definite disappearance of race as a sole explanation of all difference in society. Race was central to inequality during apartheid, but its stubborn and persistence in the discourses about the meaning of our constitutional dispensation is largely a reflection of the past. In summary, we need class to enter the constitutional discourses. When was the last time a judgment of the Constitutional Court referred to class and not race? While the immediate future of inequality appears relatively secure, the future of race as defining inequality is not that secure. This is not to take economics into judicial determination. Judge Ismail Mohammed already opened the space in constitutional language that our constitution intends to repudiate that part of the past which is disgracefully racist, authoritarian, insular, and repressive. It is arguable whether a colonizing and totalizing colonial legal system has any defensible parts. I don't wish to enter that debate today. But the larger point I want to make is that by adopting the Constitution, South Africa began a path towards the negation of its colonial and apartheid past. The Constitution is the primary means through which we can contend with our past and imagine a new future. But that is not possible if we are trapped in a rule of law paradigm of the society we seek to transform. There is a third constraint to the possibility of the rule of law as releasing or unleashing the emancipatory forces embedded in it, and it is the crisis of legitimacy. Recently, in fact, in September 2021, it was reported in the newspapers that there is mounting anxiety in the legal profession that respect for the rule of law in this country is declining. Government ministers and sections of the media have derided judges as enemies of the people, and lawyers are attacked as activists. And it was also stated that it is dangerous for the government to attack the legal professionals for just doing their jobs, and to do so undermines the framework of laws. Luckily, this was not about South Africa, but it was about the United Kingdom. But it is reflective of a larger point. Alexis de Tocqueville visited America from France in the 1800s. His observation was that scarcely any political question arises in the United States that is not resolved sooner or later into a judicial question. The relationship between the judges and the politicians is a historically tense affair, as I pointed out at the commencement of my address. But the rule of law can only sustain itself if it carefully navigates the difficult terrain of the relationship between law and politics. In the first few years of the existence of the Constitutional Court, Nelson Mandela made certain to secure the standing of the Constitutional Court. But our experiences now are that Mandela's assurances can no longer be guaranteed. Politics as brute force has returned. Its message is transformation. Its mission, however, is power. The project of transformation should therefore appreciate the project of political power, sometimes that pretends to be transformation. There is a fourth constraint to the rule of law. It is not political in the sense of capital P, but it is political because it engages with what the rule of law should do in the public space. Let me remind you of one of the things that de Tocqueville said about his visit to America. This is what he said: men who have made a special study of the laws derive from occupation certain habits of order, a taste for formalities, and a kind of instinctive regard for the regular connection of ideas, which naturally render them very hostile to the revolutionary spirit and the unreflecting passions of the multitude. He may have been correct, but he was describing a different society. The key to be taken from de Tocqueville's observations is that legal training empowers us to be skeptical of the passions of the multitude, to be skeptical of the views of the public, and to be skeptical of the ways in which democracy functions, but at the same time to be respectful of theory, of legal principle, and of written laws. That skepticism, however, does not mean that lawyers should pay no heed to popular views or what is in the public square. But we must remember Justice Powell in a case of Furman versus Georgia, where he distinguished between the so-called public interest and the public views. This is what he said: the weight of the evidence indicates that the public generally has not accepted either the morality or the social merit of the views so passionately advocated by articulate spokesmen for abolition. But however one may assess an amorphous ebb and flow of public opinion, generally on a volatile issue, this type of inquiry lies at the periphery, not the core of the judicial process in constitutional cases. The assessment of popular opinion is essentially legislative and not a judicial function. This was repeated by Justice Jackson in West Virginia State Board of Education versus Barnett. The very purpose, he said, of a Bill of Rights is to withdraw certain subjects from the vicissitudes of political controversy, to place them beyond the reach of majorities and officials, and to establish them as legal principles to be applied by the courts. One's right to life, liberty and property, free speech, free press, freedom of worship and assembly, and other fundamental rights may not be submitted to vote. They depend on the outcome of no elections. Our own Justice Chaskalson returned to this topic. This is what he said in S. versus Makwanyan, his very first judgment as a justice of the Constitutional Court. Public opinion may have some relevance to the inquiry, but in itself, it is no substitute for the duty vested in the courts to interpret the Constitution and to uphold its provisions without fear or favor. If public opinion were to be decisive, there would be no need for constitutional adjudication. The protection of rights could then be left to Parliament, which has a mandate from the public. So, in sum, popular views, or sometimes referred to as populism, are ideas that rest on extreme majoritarianism. They claim absolute, unlimited sovereignty. They claim morality of the people, and they claim a collective set of ideas. But ultimately, they are parasitic. They are parasitic to the democratic order. They hijack the democratic order because they subvert their institutions. Populists, those that are in power and those that are in the public square, often make opportunistic use of democratic institutions and constitutional structures. They treat them as a mere facade that legitimates their power. They take advantage of them for as long as their purpose of advancing whatever sectarian interest is served. So although on the face of it, populism seems to embrace democracy, claiming to represent the common people, usually it is a ruse. Its ultimate goal is to destroy the institutions of constitutional democracy. And the rule of law is one of those concepts that populists sometimes embrace. But in its principled form, it is fundamentally opposed to the form of populism that pays no heed to democratic institutions. Yet, and I want to now go to my last point, there is paradox in all of this. Although I say that we should be skeptical of what is debated in the public square, and we should be skeptical of what is said by politicians in the name of the public, the judiciary does need public trust. And there is a difference between the judiciary's reliance on public trust and the judiciary's swaying in whatever way public opinion flows in a particular era. In the final analysis, the people must believe in the integrity of their judges. Without the trust, the judiciary cannot function properly. If the judiciary cannot function properly because it is distrusted, the rule of law must die. It is crucial to preserve the public trust in order for the judiciary to perform its arbitrary role. It is crucial to maintain that belief because it is only that belief that will protect the judiciary against vilification. What should the judges do to protect themselves against the erosion of public trust and the exposure to public vilification? One of those devices, perhaps the only sustainable device, is the method of adjudication. Judges should decide cases by reference to the law. They must decide cases by reference to their own independent interpretation of the Constitution. They are accountable, not accountable to the multitudes, but accountable to the Constitution itself. This is what was said in S. versus Mamabolo about how this might be achieved. The most important of these functions is that judges speak in court and only in court. They are not at liberty to defend or even debate their decisions in public. It requires little imagination to appreciate that the alternative would be chaos. Moreover, as a matter of general policy, judicial proceedings of any significance are conducted in open court to which everyone has free access and can access the merits of the dispute and can witness the process to its resolution. This process of resolution ought, as a matter of principle, to be analytical, to be rational, to be reasoned. The rules to be applied in resolving the disputes should either be known beforehand or be debated and determined openly. All decisions of judicial bodies are, as a matter of course, announced in public, and as a matter of virtually invariable practice, reasons are automatically and publicly given for judicial decisions in contested matters. All courts of any consequence are obliged to maintain records of their proceedings and to retain them for subsequent scrutiny. Ordinarily, the decisions of courts are subject to correction by other higher tribunals, once again for the reasons that are debated and made known publicly. So the protection ultimately of the rule of law lies with the judges. They are charged to promote it, but it does not lie with their engagement in the public square with the politicians, but with the scrupulous observation of the Constitution. Finally, it is necessary to note that not only is the rule of law a sacrosanct principle embedded in the Constitution, its manifestation is included in Section 165 of the Constitution. Unlike many other constitutions in the world, our Constitution expressly endorses the statement that judicial authority of the Republic is vested in the courts, it expressly states that the courts are independent and subject only to the Constitution and the law, which they must apply impartially and without fear, favor, or prejudice. This, I believe, is the greatest protection of the judiciary against internal and external attacks. The rule of law functions well in democratic systems. In our country, it has functioned relatively stably, although if one takes a longer historical trajectory, there have been moments of external attack. But not always. Even in autocratic systems, the principles of the rule of law can influence an undemocratic and oppressive system in ways that foster the respect for human rights and create conditions for freedom. We saw this during apartheid. It is in this latter respect that the rule of law is most potent as a catalyst for change and as an indicator for the possibility of change. This is why I believe we have to fight for the rule of law. Without it, the democratic enterprise will crumble. Mandela's vision will never be achieved. Thank you.
Okay, thank you so much, Advocate Tembeka Nkaitobi. I must say that as someone who has had an opportunity to listen to you on many occasions addressing various topics, I must say that one of the things that I really enjoy about listening to you addressing any topic is your thoughtfulness and your incisiveness. I must say that I have really enjoyed that aspect about you. So thank you so much for such a thoughtful and incisive address on this topic. You're addressing a very difficult topic here, especially now in this country when the rule of law has plunged this country into a crisis recently. So it's not a very easy topic to address in this country right now, but you have really attempted to do that. So the topic attracts a lot of controversy. When you talk about the rule of law in this country at present, it often attracts a lot of controversy. And I see in your address, you try to touch on some of the points or some of the factors which would explain as to why the rule of law would attract a lot of controversy, especially in political circles. So the one thing that you've pointed out for me, there are several factors that you've alluded to this effect. The one that really stood out with me was the fact that judgments have an impact on political choices. So if judgments have an impact on political choices, it should not really be surprising that sometimes we would have so much controversy in relation to the rule of law and judgments that come out of our courts. And we've had a number of cases. We see a lot of cases coming out of our courts, which clearly have an impact on political choices that various political players may have. So we shouldn't be surprised, ladies and gentlemen, to see that there's so much controversy that results when we talk about the rule of law. So that really stood out for me. And of course, there are several other factors that you alluded to, which would explain why there's so much controversy when it comes to the topic of the rule of law in this country. So without any further ado, ladies and gentlemen, it is that moment when you are given an opportunity to ask some questions, to pose some questions to our speaker. We did indicate to you that you must use the Q&A function to ask your questions. We already have a few questions here, which I am going to direct to our guest speaker. Advocate Tembeka Nkaitobi, there's a question here. Let me start with a question from Velin Holness, who welcomed you. She's got a question here. So the question reads as follows. I'm going to read it out. Okay, she says, debates around the meaning of and defense of the rule of law in contemporary South Africa, whether post-crisis situations or not, are held in academic circles from time to time, like we're doing now. we do this a lot as academics. And then the question is, how can we make these debates more accessible, not just in format and audience, but also in relation to the content? And that's a great question. This is the question that we need to ask. We have these debates in academic circles, but the question is, how do we make these debates more accessible, not just, how do we make these debates accessible in relation to the content when we're dealing with the rule of law? So that's the first question. So I'll let you attempt that one, and then we will follow with the rest of the questions. Over to you.
I mean, look, I agree with the observation that these debates are, in a sense, elite debates, but at the same time, they are fundamentally important to the nature of society we're trying to build. One of the points that one of the ideas I've been toying around is what exactly is the point of this rule of law? Because I've attempted its definition, and I've shown its constraints, and I've shown how it can be protected from within the judiciary and among the lawyers by a scrupulous adherence to the provisions of the Constitution, as opposed to an attempt to engage in popular discourse. I think that to try and answer what is the point of it? I mean, the one way of understanding the point of it is that it is an attempt to try and define what a good society will look like. In other words, what kind of society are we trying to construct? And what will it look like? So that's one of the functions it performs, is attempting to help us to think about what a good society would mean. So if that is the point of the rule of law, which is helping us to develop a legal means of analyzing a good society, then of course it is not a matter of interest only to the lawyers, it is a matter of interest to the public as a whole. So it becomes then quite critical that the discussions need to go beyond the classroom, and they need to go beyond the realm of the lawyers. But I mean, this is a topic we've debated many years about many things: socioeconomic rights, administrative law, every academic topic that there is in the world. The concern is always, let's take it beyond the classroom. But we are never able to do that, because we also sort of are self-referring, it's like we are just each other's echo chamber, So, I mean, although I agree with it, I can't think of any practical mechanism, because I must confess that I myself have become a snob in the sense of these discussions. It's not as if tomorrow I'm going to be in a township talking about the rule of law. I'm quite happy to be talking to academics about the rule of law, or to practitioners or to judges about the rule of law. So I think, I'm also to blame for it. There is another way of reaching out to the public, which is perhaps inviting the media, to these conversations so that they can report what was discussed. But if the point is, how do we get the public to participate in the discussions about the meaning of the rule of law? That's a good point, but I don't have an answer. The only thing is that I can just plead guilty to perpetuating the elitism that goes into these conversations. I mean, I'm here today, I'm not in Soweto or in my village.
Yeah, no, absolutely. It's a difficult one. It's a difficult one, and I must say that this question, it links up with another factor which you pointed out as important in understanding the rule of law, the need for substantive equality and the need for class to enter constitutional discourses. I think that is linked to that question. And of course, the question is, how do you do that? How do you ensure that happens? We know that there's a need for us to have all of those things taking place. But the question is, how do we get there? And I think that's really the challenge for this country. That's our struggle. We know what needs to be done, but we seem to be perpetually trapped in terms of how do we get there. The agenda is very clear as to what needs to be done, but how do we get there? Yeah. All right. Let's go to the next question here. Okay. There are some questions which have come from Dan Mafura. The first one is, so he's talking about one of the things that I've pointed out in relation to substantive equality. The question is, does this substantive conception of the rule of law not risk extending the role of judges into areas where they are not necessarily competent? And he follows up by asking,
you're frozen on my side. Chivas froze on my side, so I don't know if it's just me or... Professor Chivas, you froze on my side.
Ladies and gentlemen, we had a technical problem there, so somehow you left us. Your picture was froze, and I couldn't hear you. So
yeah, it keeps saying recording stopped, so I don't know what was going on. But I had the first part of the question from Dan, which is the risk of engaging judges on topics that they have no expertise.
Yes, exactly. Yes, please, if you could attempt that one.
Yeah, I know that the point is true. It's well taken that there is a risk. There is a risk of, judges entering a space that they have no expertise on. But I think that what I'm trying to debate seriously about the richer conception of the rule of law that doesn't focus on legalism, like pure legalism, is to think about how we reconstitute our notions of property. How we reconstitute our notions of contract and notions of delict, as sort of private law branches that largely have been left untouched by the Constitution and largely still function along the Roman Dutch understanding. So the question is engaging with those concepts and thinking about them in multidimensional ways, which would fit the framing of the Constitution. Last week, I spoke at an event at Oxford, and I began thinking seriously about the need to revisit our notion of private property, at least as far as it concerns land. But I think the same topic can be made about contract, that the ideas of equity and good faith and the role they played in construction of contract. I mean, that needs a fuller elucidation than we've been able to do so. And the same with intellectual liability, which traces back to Roman Dutch conception. So that's one angle in which I think that the rule of law could help. If the rule of law has a substantive dimension, it could help to inform dealing with contracted property. The second thing about it, which is to answer now directly Dan's point about the risk that judges would have no expertise to engage with questions of class and economic standing. I think that what judges can do, they obviously can't train themselves up to be economists, but I think what they can do, the rule of law could play a role of qualitative examination of explanations given by the government. So typically the case you get if in a case about distribution of resources, and those cases are usually about housing or water, but they are primarily cases about what is the optimal way of distribution of resources in a society. The judges obviously do not know that. They don't know how the budget works. But I think what they can do is to increase the levels of accountability by a heightened scrutiny, of the evidence that the government presents. So often you find judgments that say the issue is budgetary and therefore it's outside of judicial competence. What I'm asking for is a shift from that kind of an understanding, a rule of law shift. In other words, when we're thinking about this idea of rationality, a rationality review, I'm thinking of a qualitative assessment of economic choices that are made by the government. So instead of saying, well, it's budgetary and therefore it's outside of judicial competence, I think that there are enough mechanisms within a rationality context of asking for greater levels of accountability. So take one case that came up recently at the Constitutional Court. I tried to act for an amicus, but I was kicked out because the application didn't meet the requirement. Take one case that was recently at the Court, and that's the case around whether or not the government was entitled to refuse to give effect to a decision concluded with the trade unions to increase their salaries. The case of the government is the reason we cannot implement the agreement is because the money should go elsewhere. And if you look at the judgment of the Labour Appeal Court, it accepts without inquiry that justification. And it almost sees the role of a judge in a very narrow legalistic sense. It doesn't see the role of a judge as expanding the scope of accountability for budgetary decisions. So it's at that level, not at the level of substitution, but at the level of increased scrutiny over those decisions. So more like a qualitative evaluation of the evidence that of the economic evidence or the economic justification usually put up by the government. So in that sense, the risk for turning judges into economists is lessened, but the scope for a substantive rule of law based inquiry increases.
Okay, thank you so much, Advocate Nkaitobi, for attempting to answer that question and to explain as to how you see the role of judges in relation to such matters which tend to be very political. Thanks for attempting to provide an answer to that question. We've got another question here from one of our academics, Christopher Givers. He has posed a question here. Actually, this question is related to the question that you have just answered, but from a slightly different angle. The question is, how are we to understand the relationship between the rule of law and justice? So I'm going to paraphrase this question. It's a bit longer, but the question is, how are we to understand the relationship between the rule of law and justice? And I must say, it's an interesting question. It's a great question, because I find that those of us who are scholars of constitutional law will know that the rule of law does not necessarily mean justice. It does not necessarily mean that. It's a double-edged sword. The rule of law can be used to advance legitimate interests, and it could equally be used to advance other things which are problematic. So I guess this question speaks to that. So how are we to, in your view, Advocate Nkaitobi, how are we to understand the relationship between the two, the rule of law and justice?
Yes,
and it gives the example of Zimbabwe. It gives the example of Zimbabwe where certain agendas were being pursued, and obviously there were certain legal measures that were being pursued, and then there were also matters of substantive equality that were being pursued. So how would you explain the relationship between the two?
Yes, I mean, it is a reflection of what I've referred to as a paradox of constitutionalism. Because on the one side, the justification that the politicians give is that they need to take the land by force so that they can give it to people that are historically disadvantaged. But on the other hand, they are breaking the law. And what the judges are doing is that putting a stop to the breaking of the law and the enforcement of the Constitution. But I think here is the question, I mean, and I think I explore this in my book, Land Matters. Here is the question about a rule of law concept that, is bereft of justice, or perhaps, endorses injustice. Here is the question: if we evaluate the progress or lack of progress in Zimbabwe now, 20 years after the first invasion, land invasions of 2000, are poor people better off or worse off? Now, if we subject the Zimbabwean experience to that inquiry, what we ultimately find is that the rule of law is always better for poor people. If you have to think about who are the ultimate victors where the institutions of the rule of law have been destroyed, my own experience is that the ultimate victors everywhere in the world, if you destroy the institutions of the rule of law, the ultimate victors are the people with money and the people with guns. So there is no experience in the world in which, at least in the sort of a post-collapse of the Soviet era, if you think about the biggest historical epoch of the 20th century is the collapse of the Soviet Union, 1989. There is no other state in which there has been economic prosperity where the rule of law has been sacrificed. So I see the rule of law as being central to economic justice and economic prosperity. And the arguments that are usually made against that, there is no empirical fact that shows that poor people are better off if you destroy the institutions of the rule of law. Zimbabwe is a perfect example. It's a perfect example about where, in fact, did the farms go? And what was the impact of the spiraling of inflation in Zimbabwe? Did it affect Patrick Chinamasa, the champion of justice, so-called champion? Did it affect Jonathan Moyo? Did it affect Robert Mugabe? No, it didn't. So we have to think of the rule of law as a friend of the poor, as an instrument in the hands of the poor, because the poor have neither guns nor money. And what they have is the rule of law. And so defending the rule of law is actually defending the poor. And so although the question presents one, at least theoretically, as paradoxical, when you subject it to an empirical examination, you are always left with, we are, as poor people, better off with the rule of law than without it.
Okay, thank you for that response, Advocate Nkaitobi. There is, so you are supposed to, we've got you until around what?
I think let's do until 20 past. I think I'll take 20 past. I see in that other side, they were slightly delayed by 5 minutes. So I've got another 5 minutes, don't worry.
Okay, perfect. So then we can perhaps take 2 more questions or so. There is a question here from, this is a tough one, so you can decide how you want to approach it. There's a question here from Vuki Lemlanduli, which goes perhaps at the heart of some of the recent events that we have witnessed in relation to the rule of law. You did touch on aspects of this in your address, so I guess you can take this question any way you would like to, you see fit. The question is, how can South Africa prepare itself for another standoff between a formidable political figure and the Constitutional Court, similar to the standoff between former President Zuma and the Constitutional Court. And then he explains what happened there. So I guess the question, we can look at this question beyond the name of a particular political figure. It could be anybody else. So I guess the question is, as a country, is it possible for us to prepare ourselves for a situation such as the one that we experienced? So you are someone who has been working in this field for some time. You've done a lot of high-profile cases where there are big political figures involved. So the question is it possible for us as a country to prepare ourselves for the standoff that we've seen? So please take the question any way you see fit.
Yeah. No. I think the question is fair. I don't feel ambushed. I think the first point to be made about this is that the underlying socioeconomic conditions in South Africa are fertile ground for populism. It's actually quite remarkable that we have not had an out-and-out populist politicians in the form, for instance, of Trump, But we've got socioeconomic conditions that are fertile ground for populism. And populism threatens to sweep everything in its wake. And it uses the language of popular sovereignty. It uses the language of the people. And it rejects institutions of democracy and institutions of the rule of law. Its pretense is transformation, but its object is power. So we've got conditions here that clearly are suitable for populist political movements, but none of them have developed so far. That's the one thing to be said. The second thing to be said is that we have to look at this in a structural way. If you think about it in isolated, July 2021 instances, I think there is a real risk that you will omit to consider the structures of society, the way they work. The event itself is new. The threats were unprecedented. And it's going to take a long, long time before we fully understand its meaning and implications. We have to go back to the basics, Professor Chivas. We've got to go back to the basics. The problem we have in this country, and I've said this many, many times, the problem we have in this country is the unfulfilled promise of constitutionalism. It's the unfulfilled promise of the constitutionalism. It's the idea in the Constitution which remains unfulfilled. It's the idea that we will be a society governed by law. It's the idea that everyone shall be treated as equal before the law. It's the idea that there shall be houses, there shall be jobs, there shall be education. All of these ideas in the Constitution that remain unfulfilled are a ticking time bomb for an explosion. So the only way to sustain constitutional democracy is, on the one hand, attending to the deep-seated structural inequality that persists. They are no longer purely racial. Although there is a tendency to focus on race, but these are no longer purely racial. What in fact is happening is a superclass and an underclass dynamic in which at the top, there is in fact racial integration, and at the bottom, there is no racial integration. And so thinking about structural inequality. On the other side of the equation is thinking about what judges should do to protect the institution of the judiciary. And the ways of doing it, again, go back to fidelity to the Constitution, making sure that decisions are reasoned, judgments are handed on time, judgments are decided by reference to the law. Although public interest and public comments are important, they are not determinative of judicial outcomes. Decisions are made fairly and in accordance with the spirit in the Constitution. That way, the judges protect themselves against populism, but they are also true to the oath of office. I don't know if anyone has ever read the oath of office taken by judges. I've had to take it every time I go to act, but it is a very sobering oath of office because it tells you that your allegiance, when you hear each case, is to the Constitution. And that never actually happens because usually the allegiance is to the people. But what we have here is expressly protected by the Constitution, which says your allegiance is to the Constitution itself. So I think we go back to these basics and as the best mechanism of protecting the institution. And then the last thing, of course, is that we should not kid ourselves. Sometimes, even where the socio-economic situation of a country is not, as unequal as it is. Take, for instance, Trump. America is one of unequal countries in the world, but it doesn't have the levels of poverty that we have. And what we had in that country was a mere exploitation of a vulnerable political scenario. But the only way the judiciary in America protected itself was by an unflinching, unrelenting adherence to the rule of law and doing their job as prescribed by their oath of office.
Thank you for that answer, Advocate Mbekani-Kaitobi. I think we probably don't have enough time now to take another question.
Well, maybe let's do one.
Okay. Let me see.
Because you said two, and then I just spent 3 minutes talking.
Okay. Let me see here. Another question. Okay. Perhaps a question that is linked to the one that you've answered. This one, it's in relation to the Constitutional Court. It's from Vukile Mlanduli. Again, the question is, obviously this question on its own is probably a loaded statement. So yeah, you tackle it the way you see fit. What could the Constitutional Court do to win the majority trust of South Africans over politicians? I'm not sure what is meant there, but I guess the question is, you've spoken about the role of judges in relation to upholding of the rule of law. I'm not sure as to whether you have any specific thoughts in relation.
I can say two things about
the one, a subject of attack when it comes to some of these controversial cases. Any thoughts there?
No, the first one is that the judges shouldn't be too sensitive. They should understand that they will be subject to attacks. Sometimes the attacks will be personal, sometimes the attacks will be intellectual, but judges will be the subject of attack. And the reason why that is inevitably in a democracy is firstly because we have freedom of speech in a democracy, but also secondly because the decisions that the judges make are very consequential decisions. These are decisions that impact on individual lives. The idea of sending someone to prison for life is a massive decision that is assigned to judges. And the idea of telling a politician that he is no longer the president is a massive decision that is usually reposed on the judges. So the first thing is anyone accepting judicial office should accept as an inherent risk of the job that there will be attacks. Secondly, judges of the Constitutional Court do not necessarily enjoy lesser popular legitimacy than politicians. Every survey that is taken always finds that the Constitutional Court is more trusted than politicians. So they are actually relatively secure. I mean, the trust I know in the latest survey shows that it is declining. But over the past 27 years, ever since we had the Constitutional Court, every survey shows that the public trust in the Constitutional Court is always substantially higher than the trust in Parliament or politicians. So insofar as the public trust is concerned, the judges of the Constitutional Court are relatively secure. And then finally, there are no substitutes, there are no shortcuts. The judges of the Constitutional Court should decide the cases in accordance with their conscience, in accordance with the Constitution, and they must be unrelenting in deciding cases according to their oath of office. There is no other way of trying to outshine politicians in the public square. The function of the judges is adjudication. The judges, as Judge Cameron once said, speak through their judgments. They're not going to win popular support by press conferences, but they are going to sustain themselves in the annals of history by a strict adherence to their own oath of office.
Thank you. I must say I don't have to agree with you, but I must say I agree with the sentiments that you've expressed towards the end of your attempt at answering that question. I think that is the only way that the judges can win the trust of the people or the public. They don't have any other means. That is the only weapon that they have, and they often emphasize this in their judgments. And so it's important that judges always remember that is the only weapon that they have. So which means that the manner in which they decide the cases becomes very critical in terms of winning over the trust of the people. So thank you, Advocate Mkaitobi, for taking all of those questions. There were, I must say, there were very good questions, tough questions, I must say, which some of them really go at the heart of some of the controversies that we've had in relation to the rule of law. So thanks for your willingness to take those questions. And I must also thank our audience for asking those very important questions on the topic. And ladies and gentlemen, we've reached the end of our webinar, and I must take this opportunity at this point to thank our esteemed guest, Advocate Mkaitobi, for agreeing to be with us today. I know very well, Tembeka, that you are an extremely very busy person. It's not easy to get hold of you. So I feel privileged that we've managed to get you to be with us this afternoon. We really appreciate this. And on behalf of the UKZN School of Law and the Dean, we would like to really thank you so much for agreeing to be with us. And we are hoping that going forward, going further, you will be part of some of the activities, and you would still accept further invitations to UKZN. We really hope that we can do that with you and establish have more interactions with you. We will really be pleased to have that. And it's clear, ladies and gentlemen, it's very clear that this topic is not just simply a procedural matter. There's so much to be said about the topic. There's just so much to be unpacked. We could sit here and discuss this topic all day. It's quite a heavy topic, and there are a lot of substantive aspects to talk about the topic of the rule of law. But yeah, this is the only time that we have, and unfortunately we have to bring this to an end. So let me also take the opportunity to thank everyone for joining us this afternoon. We know that everyone is busy, but you chose to be with us. So we thank you so much for your attendance. And I must also take this opportunity to invite you to our second webinar. You know that this is part of a two-part webinar series that we're having in relation to the rule of law in the aftermath of the July unrest. So this was the opening webinar, and I think it's a wonderful opening that we had, where we were able to touch on the rule of law in general, and also look at many factors and aspects affecting the rule of law in South Africa. And we were able to pick Advocate Mkaitobi's brain on a number of important issues on this topic. So please, if you have time next week, do join us for the next webinar, which will be looking at some of the particular aspects in relation to the July unrest, including the criminal justice aspect of it. So we do invite you to be part of that one as well.
Professor Chibasa, may I be excused, please?
Yes, Siyabulela, you are excused. Thank you so much.
And thank you for the invitation.
All right, thank you.